welcome to the talk I'm giving with my colleague Gemma de Cordova in relation to parking disputes. We've selected this topic because it seems that virtually every case that's come across my desk over the last few years seems to have had some element of some sort of parking dispute involved in it. And it's absolutely extraordinary how willing residential property owners are to litigate about such matters. We're going to be covering a number of different topics, which I've set out in the second slide here. Obviously, there's a number of overlaps between those slides because most cases can consider a number of different points, but this is how we've organised things for ease of reference. And because of the extent of topics that we need to discuss, what we're going to do is to invite questions by email, and we really do welcome such questions at the end, rather than allowing time out of our presentation for questions. I'm now going to hand over to my colleague Gemma, who will deal with the question of the nature of a parking easement to start off with.
Good afternoon, everyone. The starting point when you come to the nature of a parking easement is the House of Lords decision in the Scottish case of Moncrieff and Jameson. The key question answered by this case was whether a right to park was ancillary to a right of vehicular access. The respondents, Moncrieff, owned a property situated between the foot of a steep hill and the foreshore. And the situation was that vehicles could not be driven onto the property itself. And as set out in the slide, you've got a summary of the facts there. The property once formed part of the lands owned by Jameson, who also retained ownership of the land between the property and the public road. And since the property had no access to the public road, the conveyance included a right of access from the public road through Jameson's land for both pedestrians and for vehicles. It included a right to stop vehicles on the servient tenement in order to turn, load, unload goods, and also to set down and pick up passengers. And the question was whether there was an accessory right in addition to these rights. Moncrieff claimed that there was an accessory right to park vehicles on the servient tenement. So at first instance, and remember this is a Scottish decision, the sheriff granted declaration that Moncrieff were indeed entitled to park vehicles on the servient tenement in the exercise of rights accessory to the servitude right of access. Jameson appealed and the Court of Session dismissed an appeal. The appellant appealed further, seeking to overturn that decision. The House of Lords, however, dismissed the appeal, upholding the original decision. And the House of Lords concluded as follows. Firstly, that a right to park could be constituted as ancillary to a servitude right of vehicular access if it was necessary for the enjoyment of the servitude access. In this particular case, the express grant in the original conveyance of a right of access had to be construed in light of the circumstances that existed at the time of the original grant back in 1973. According to Lord Roger of Illusory, the test was this: whether or not it was necessary for the comfortable use and enjoyment of the servitude, or in other words, whether it was essential to make the servitude effective. He did caution, however, that it was not necessary for it to be shown that all of the rights that might later be claimed as necessary for the comfortable use and enjoyment of the servitude were actually in use at the date of the original conveyance. It was sufficient, it was thought, that they might have been considered to have been in contemplation at the time of the original grant, having regard to what the dominant proprietor might reasonably be expected to do in the exercise of his right to a convenient and comfortable use of his property. The House of Lords also held that in the particular and unusual circumstances of the instant case, the rights ancillary to the express grant of a right of access in favour of the dominant tenement included a right to park vehicles on the servient tenement, insofar as that was considered reasonably incidental to the enjoyment of the dominant tenement. It would have been a great inconvenience to the pursuers, to the Moncriefs, if they were unable to park their vehicles on the servient tenement, given that there was nowhere else for them to go. So on the facts of this particular case, it was reasonable to assume that the exercise of the right would not create an undue burden on the servient tenement, and therefore it was considered unnecessary to set a limit, as Jameson has sought to do, on the number of vehicles that might be parked. So that's a brief introduction for you. I'm going to hand you back now to Kerry, who will consider some further issues concerning parking easements.
Thank you, Gemma. I'm going to talk now about parking incidental to a right of way. And the first of those cases is Bulstrode and Lambert, which I'm sure many of you will remember. It's the famous old auction mark case in which there was an express right of way giving a right to pass and repass with or without vehicles for the purpose of gaining access to the auction mart. The facts were that the background was that the entrance was obstructed in 1944, but later it was widened. And in considering the case, Mr. Justice Upjohn considered that it was permissible for there to be access for parking for the purpose of loading and unloading. Because the rights depended upon the express grant, it was irrelevant that the entrance could not have been used for the entrance for taking in furniture until the 1950s. So that's the starting point. However, moving on to slide 9, we can see, of course, that it's not always the case that a right of way includes a right to park, rather the contrary. The case of J&O Operations Limited and Kingston and St Andrew Corporation was a case involving commercial premises, but the principle is good and widely applied. And in that case, the Privy Council had noted that very often commercial premises were let without the benefit of adjacent private parking, and therefore an easement along a road would not necessarily lead to the creation of an easement of parking. So it is important to remember, although there can be circumstances where an easement of parking can arise, it's not something that automatically arises. Moving on to a case of my own, this is a case of Vance and Collerton, which was a High Court appeal heard last year. This is a fairly typical dispute in many ways between two neighbours who shared a driveway. The Vances owned the cottage at the rear of the Collertons' larger house in front. The Collertons owned the drive, and the Vances had a right of way at all times and for all purposes. They objected to the Collertons parking at the front of their drive on the basis that it was not, it didn't allow them the best form of access to their own property. But the difficulty was that they issued proceedings to assert that right without considering their rather more basic difficulty, the fact that they'd created a hard standing for the purpose of parking on their property without a vehicular right of access. And what we successfully argued, and what was upheld by the High Court, was that because there was a fence and a hedge obstructing access at the time of the grant, in those circumstances, the right of access was not vehicular. And so the Vances were left with a large cost bill and a substantial loss because they were no longer able to park, although the court was prepared to uphold the decision that they could select where they wished to access the drive. Moving on to a second topic, which I'm going to address before handing back to Gemma. The creation of easements by Section 62 of the Law of Property Act, which I've set out on slide 12, and with which you'll be familiar, was a case considered, was a position considered in the case of Hare and Gilman. In this case, the tenant of a property was given a right to park by her landlord, and she contended that a letter giving such permission, followed by the subsequent conveyance of the rented property to her, led to giving rise to an easement under the Law of Property Act. The judge held that although permission to use the forecourt was capable of being an easement, because it wasn't intended that the right was permanent, it didn't apply. She appealed and did so successfully to the Court of Appeal, which held that the use of the forecourt was not temporary in the sense that it was due to come to an end at any particular point, nor was it secure. But even such a precarious right was capable of coming within Section 62. So I always think Hare and Gilman's quite a useful case in terms of the acquisition of parking rights. And of course, it's perhaps rather serves to emphasise the next point I'm going to make, which is that it's essential that a parking easement complies with the usual rules for an easement. And the key case that sets out that principle is at slide 15, and that's London and Blenheim Estates and Ladbroke Retail Parks case, in which it was confirmed by the Court of Appeal in relation to an option to create an easement, that because the essential ingredients of an easement were not present, namely the dominant tenement, in those circumstances there was no parking easement. That is a principle which leads me neatly on to the next case I want to consider, which is one that I suggest you watch the space on, because both parties in this case have lodged applications for permission to appeal to the Court of Appeal, in fact in the last week or two. Post Hotels and Cousins is a case involving a hotel which converted one of its outbuildings, namely a garage, into a laundry. The resident, Ms. Cousins, objected to the conversion and took to parking right in front of the laundry doors, which prevented access by way of the use of large industrial shopping laundry trolleys, which were needed to be used by the hotel. After numerous attempts to resolve the matters through sheer common sense, including a suggestion that Ms. Cousins moved a mere 5 yards, given that the road was quite often not fully occupied, then proceedings were issued and relief was obtained, including declaratory relief that she was not entitled to obstruct the doors and was causing a nuisance by so doing. But Ms. Cousins obtained a declaration that she had in fact acquired a parking easement by virtue of her and her predecessors having parked on the spot for a number of years. This was challenged, and this is challenged by Post Hotels on the second appeal, on the basis of really quite an interesting point that arises in Gale, namely a very old case called Lestrange and Pettifer. And essentially what is being argued is that because Ms. Cousins was parking not as something that was dependent upon her property, but rather as something that was just in common with members of the public, because it's a road used by many of the local residents, many in the locality, that in those circumstances it wasn't sufficient to give rise to an easement. And that is one of the points that permission to appeal is being sought on by my clients, the hotel. A secondary point which is of interest is whether such declaratory relief ought to be granted in circumstances where the owner of land is not named as a party, because of course it's a substantial right to obtain an easement of parking, and the relief sought by Ms Cousins didn't involve any application to join the owner, who was capable of being ascertained. I also ought to add that Ms Cousins is herself challenging the relief granted to Post Hotels by way of a second appeal, although Mr Justice Morgan on the first appeal in the High Court did very much characterise her appeal as really a challenge to the findings of fact of the judge. So it remains to be seen whether the Court of Appeal will be interested in either point. But I'm certainly interested in the first point, and I think it's something that it's possible that you may hear something further of on in due course. What certainly those cases do show, though, is the extent to which parking rights are valuable. And I think one of the reasons why such cases are pursued so vigorously by parties is because of the potential cost of not having parking rights associated with residential accommodation, indeed commercial premises as well. So now I'm going to hand back to my colleague Gemma, who's going to look at the topic of acquisition of parking rights through adverse possession.
Thank you, Kerry. So, it is possible to acquire parking rights through adverse possession. An example of such a case where the High Court did so find is the decision of Dyer and Terry, a 2013 decision. Briefly, in this case, the Terrys pursued an application to alter the land register in respect of 6 different parcels of land. Ultimately, the High Court found they were successful in respect of 2 of the parcels of land. And what the Terrys set out to do was to amend the register by removing those parcels from the defendant's title and re-registering them within their own title on the grounds of adverse possession. The High Court determined that the Deputy Land Registry adjudicator had been entitled to find that an adverse possession claim succeeded, as I indicated, in respect of 2 of the parcels of land. Now, the key elements in this case, as with all successful claims for adverse possession, were that A, there was sufficient evidence of exclusive physical possession, and B, there was sufficient evidence of the intention to possess. Something that ought always to be borne in mind with claims such as these, and all parking cases, as well as adverse possession cases, is that of course all cases will turn on their own particular facts, and particular attention must be paid to who is using the land, how it is that they are using the land, and what evidence there is, not just of their use of the land, but any physical demarcation. So as we see in this case, of particular relevance was the fact that the land was enclosed by a fence, and it was used by the Terrys as an overspill paddock as part of their equestrian activities. So the Terrys were able to evidence a change of use, and this was considered to be strong evidence of treating the land as an owner of the land would. By 1988, they had taken down the fence and partly laid the area to hardcore and began to use it for parking. And again, this was consistent with exclusive physical control of the land. One of the parcels of land was concerned a small area in front of the Terry's house. That's the area that they used for parking. And again, it was considered by the court that this was exactly the way in which one might expect owners of a property to use an area in the front of their house to use it for parking. So in that particular case, the Terrys were successful in asserting their rights acquired through adverse possession to park vehicles. I would suggest that if you would like some useful analysis of adverse possession cases and how the law is applied to a variety of facts, I would recommend the analysis at paragraphs 42 to 47 of the Dyer and Terry judgment. Next topic that we're going to consider is the question of whether ownership is rendered illusory. So we're going to look at some examples now where the courts have considered this question and the extent to which the landowner's use of the land is impacted by the other user or users of the land in order to determine what parking rights, if any, the user of the land has. So if we start by going back in time for a moment, circa 70 years or so, and we will look now at the case of Copeland and Greenhalgh. In this particular case, the plaintiff was the owner of an orchard and an adjoining house. And the access to the orchard was from the road, but via a strip of land around 150 feet long. And the width of that strip of land varied from about 15 foot at the road entrance up to around 35 foot in the middle, and then it contracted towards the orchard as it got closer towards the orchard at the end. The defendant in this particular case was a wheelwright, and his premises sat opposite the plaintiff's strip of land. The plaintiff brought this claim for an injunction to restrain the defendant from placing and leaving vehicles on the strip, so in order to prevent parking. Now, the defendant claimed that he had the right to park, and he argued that his right was a prescriptive right. He argued that he'd been using the land to park and store vehicles and repair vehicles for 50 years. And that so long as he left space for access to the orchard for the plaintiff, then his use amounted to an easement and he ought not to be restrained from continuing to use the land in that way. Well, the court rejected the defendant's claims on the basis that what he was asking for effectively amounted to possession or equal use alongside the owner. So the plaintiff was granted his injunction. And as is set out on the next slide, Mr. Justice Otjohn sets out some analysis. He starts by saying that he thinks that the right claimed goes wholly outside the normal idea of an easement. And if we jump down to around halfway through the paragraph, the highlighted section, he said, "In my judgment, that is not a claim which can be established as an easement. It is virtually a claim to possession of the servient tenement, if necessary to the exclusion of the owner or at any rate to a joint user, and no authority has been cited to me which would justify the conclusion that a right this wide and undefined in nature can be the proper subject matter of an easement. It seems to me that to succeed, this claim must amount to a successful claim of possession by reason of long adverse possession." So, as I said, the plaintiff got his injunction. So in that particular case, the defendant's use of the land went too far, and the court was not prepared to justify that by way of granting or authorising that particular use. The next case that we're going to look at is that of Batchelor and Marlowe, 2003 decision of the Court of Appeal. So without going too far into the detailed facts of this case, this is a case that concerned parking on a strip of land, and the question was whether or not an easement had been acquired. The key takeaway from this decision, and it is an important one, is that the Court of Appeal held that the question to be asked and determined in cases such as these was whether or not the servient owner still retained reasonable use of his land. In overturning the judge below, the Court of Appeal held that granting such rights would leave the plaintiffs without reasonable use of their land and so could not constitute an easement. They concluded that the owner's use was rendered illusory. However, as I set out on the following slide, the conclusion of the Court of Appeal in this particular case has been doubted. You will recall at the start of our session when I described the details of Moncrief and Jameson, that was the case with the property at the foot of the cliff. The court were considering in that case whether the right to use land for parking was ancillary to vehicular rights of access. Now, it does bear looking at the observations of Lord Scott and Lord Newburger. Lord Scott suggested in Moncrief that Batchelor needs some qualification. He expressed doubt that Batchelor had been correctly decided, and he suggested that the test might be whether the servient owner retains possession and control of the land in question, subject to the reasonable exercise of the right in question. However, and this is an important takeaway, Batchelor, although expressly doubted by in Moncrief, it has not been overruled, and therefore remains the relevant test to be applied to cases such as these. And it seems to you, Kerry and I, that in order for this one to be resolved, we will need further case law, another case, and most likely parties with deep pockets, to appeal this matter up to the Supreme Court to resolve this question. Unfortunately, in Moncrief, despite expressing doubt, they didn't quite go far enough. So Batchelor and Marlowe stands. The next example that I want to give a brief mention to is the case of Verdi and Chana, 2008 High Court case. And again, without spending too long on the details of this particular case, because all of these cases turn on their individual facts, it's useful for practitioners and those with parking issues to be aware of the various fact patterns and circumstances that have been before the courts previously. But of course, each case will turn on its own facts. But what this case is an example of, it shows that the courts are trying to be consistent in applying Batchelor. In this particular case, the High Court held that the adjudicator had been wrong to apply what had been said in Moncrief by Lord Scott and Lord Newburger, because, as we've already dealt with, Moncrief did not go so far as to overrule Batchelor. The other important observation here is that in Verdi, the servient owner was still able to use and maintain the land that she owned and to deal with it as an owner would, and therefore her use was not rendered illusory. So that's Verdi and Chana. Kettle and Bloomfold is the next decision that we will look at. It's a 2012 decision of the High Court. And this is a case which illustrates a very important principle for leaseholders, in particular, to be aware of in circumstances where landlords might be seeking to redevelop or extend existing sites. We're seeing a lot of that, rooftop developments or otherwise taking over car parking spaces or other ancillary buildings or areas of land surrounding leasehold blocks. And this is a case in which leaseholders wanted to get an injunction to restrain the landlord from building on their car parking spaces, as had been proposed. Of course, if we're dealing with leaseholders, the starting point is always the lease itself. And in this particular case, the leases stated that the landlord demised to the leaseholders the premises together with the rights specified in the second schedule. And then when you look at the second schedule, the rights in the second schedule included the sole right to use designated parking spaces. The landlord sought to argue that it had the right to require the leaseholder to use other parking spaces in place of those originally allocated to the leaseholders, or alternatively, that the offer of alternative parking spaces, which were equally convenient, meant that any remedy should be limited to nominal damages rather than an injunction. Reassuringly, I would suggest, the injunction was granted. Whilst it was held that the lease did not demise specific parking spaces to the leaseholders, the conclusion in this case was that the right to use the parking spaces amounted to an easement, and on a proper construction of the lease, the landlord did not reserve any rights to build on those parking spaces or to reorganise the way in which they were allocated to the leaseholders. There was no, the court was not prepared to imply a right or to read into the lease that there should be any right implied to change the designated parking spaces. Generally speaking, it is not open to a servient landowner to unilaterally seek to extinguish an easement over one area of land, even if what they're offering is provision of an equivalent and equally accessible and convenient easement over another. So that is one to be aware of, and also it's important principle for freeholder developers to be aware of before they go about undertaking these developments. The next example is another leasehold dispute, albeit in a commercial context, is R-square properties. Now, the argument in this case was again as to whether or not the owner's ability to use the land was illusory. And in this particular case, the lease granted to Nissan gave Nissan the exclusive right to use 80 parking spaces. And this was determined to amount to an easement. The landlord argued that if it couldn't use the space for parking, then it didn't have any reasonable use of the land. But the landlord's argument failed in this particular instance. The judge was entitled to conclude that the landlord's rights were not illusory and it had not lost reasonable use of land just because of Nissan's leasehold right to use these 80 parking spaces. And again, this is a case where the court sought to distinguish from Batchelor and Marlowe because, of course, Batchelor and Marlowe remained binding on them. But the bottom line in the R-squares in Nissan case is that ownership was not rendered illusory. Moving on then to look at Begley and Taylor. Kerry mentioned earlier that neighbours of residential property do seem, and rightly so, that parking rights are very important to them. And Begley and Taylor is another example of a neighbour dispute regarding the erection of a gate along an access road. In this particular case, the claimant sought a determination as to the scope of their rights of both rights of way and rights to park. Now, the claimant did establish a right to park based on long user, but this did not render the defendant's rights of way illusory. So the claimant was successful in that particular case. And again, Batchelor was distinguished on the grounds that the defendant's rights were not rendered illusory. The next and final example before I hand back to Kerry is just worth a brief mention, the Della Kuna and Big Apple marketing case. Again, this was a leasehold relationship and the question of parking rights. In this particular case, it was held that the lease properly construed did grant an easement and it was effective. The defendants sought to argue that it wasn't effective and that their use of the land was illusory by reason of the fact that parking rights had been granted under the terms of the lease. But similarly to the other cases that we've looked at, properly construed, the defendant's use of the land was not rendered illusory just because a landlord grants rights of way, rights of access, rights of parking is not sufficient to render the use of the land illusory. Yes, so moving on then to deal with construction, and this is the final topic I'll deal with before I hand back to Kerry. Now, we've already touched on a few cases where the wording and in turn the construction, either of the original conveyance or otherwise of the lease, will be the key really to determination of what rights, if any, are in play, and that they ought always to be the starting point. So in the first of three cases that we'll look at, Smith and Garrett, a 2004 decision of the Court of Appeal. This case concerned an application for an injunction to restrain parking of vehicles along a private road. The obligation was not at any time to park vehicles upon or place any articles upon or in any way obstruct the free passage of any part of the roadway over which the other persons had a right of way. The restriction then was against parking vehicles, but it was not intended to be an absolute restriction. It was to be construed as a restriction against parking vehicles in a way that would cause interference with the exercise of the rights of way, whether they were granted in the conveyance or granted in an earlier conveyance or indeed granted subsequently. The Court of Appeal accordingly accepted that there was a right to park on the verge as it did not obstruct free passage. The next case then that we'll consider is Waterman and Boyle. Again, parking along a shared driveway. And in this particular case, the Court of Appeal held that there was no such right to park along the driveway because an express right of parking had been included in the grant itself, and so there was no need to imply any further rights. And I've set out there an extract from the judgment, paragraph 31, where Justice Arden says, in my judgment, if the parties had intended any further right of parking, there would have been an indication to that effect in the transfer. Nothing in the surrounding circumstances at the time of the transfer supports the implication of any further right. Indeed, I would indeed go further and hold that where there is an express right attaching to the same property of a similar character to the right which is sought to be implied, it is most unlikely that the further right will arise by implication. The circumstances would have to be quite exceptional. And it's also worth being aware of the warning which is set out on the following page. We won't need to go through all of it, but the bit in bold at the bottom, where it was said that parties to other boundary disputes and their advisors should also at all times have this point firmly at the forefront of their minds and seek to resolve their disputes accordingly and without resort to complex and expensive litigation. So a warning for all litigators there. Heed it or not, as you will. The final example then of a case involving the construction of access or parking rights is Overcombe Properties. The claimant owned the freehold of the block of flats, and the defendant was the management company. The claimant wanted to mark out parking spaces on the forecourt and to grant exclusive licences. Now, in this case, the terms of the original leases had provided for the right of lessees and persons authorised by them to use the forecourt for the purposes of access and egress, but also for the right of the lessor to develop the property, notwithstanding that the access of light or air to any easement may be obstructed or interfered with. The lessees in this case contended such interference would be substantial, which would not be permitted by the wording of the lease. So, what was the decision? Looking at the lease as a whole and the situation of the flats, the words obstructed or interfered with, referred to in paragraph 5.5, should be read as permitting acts which would otherwise amount to an unjustified obstruction to or interference with an easement, and which would otherwise be an actionable nuisance, but not acts which would, for practical purposes, destroy the easement itself. So on the facts, whilst the proposed scheme would cause some congestion, some delay and some inconvenience, it would not deprive the lessees of all reasonable access. So the proposed scheme, it was held, was therefore of the kind that had been contemplated by the drafting of the lease. I'll now hand you back to Kerry for our next topic, which is parking schemes.
Thank you, Gemma. I hope you can all hear me all right. The parking schemes involves a trio of cases that I'm going to look at. The first of these is Said and Plus Trade. That was a case involving a flat within a mansion block whereby tenants had a right to park on the forecourt. The landlord was carrying out some development works and during the course of the construction denied the right to park, and then at the conclusion of the works reduced the number of available spaces for the residents from 13 to 4. The claimant issued a claim for damages and sought an order that she could park in the spaces that had been available prior to the changes. She said that she had an easement and that reducing the number of spaces amounted to a substantial interference. She succeeded before the Deputy High Court judge in this case and received obtained an injunction and damages. And on the appeal of the landlord to the Court of Appeal, that was dismissed. What the Court of Appeal said was that she'd been granted a legal right to park on the forecourt, and it was plain that having removed her right during the course of the works, which took place over 3 years, was a clear derogation from the right granted under the lease. Furthermore, the reduction of the spaces from 13 to 4 constituted a substantial interference with her right to park. So that's the first of the cases. The second of the cases is Shah and Colvia Management. This is another example of commercial case, but the principles are applicable more widely. Effectively, what happened was that the management company, of which all the lessees were shareholders, instituted a car parking control scheme as a result of particular problems that occurred on the site with regard to parking areas and them being inadequate to meet demand. They took this step after various other steps had failed. And finally, they settled on a ban on overnight parking unless a fee was paid. 64% of those residents approved this scheme, and proceedings were issued by some of the minority who didn't approve on the basis of an allegation that the scheme was unreasonable. Now, the minority persuaded the High Court judge that it was unreasonable. Firstly, they said that the setting of the overnight rate had not been set in a reasonable way, and secondly, it would be unfair in terms of the rates bill was going to be not shared out amongst the lessees as a whole, which was what was envisaged under the terms of the lease, and therefore the scheme was unreasonable. The CMC appealed on 2 grounds. First of all, that the judge was wrong to rely upon the failure of the management organisation to research local rates of charge. And secondly, the judge was wrong to reject the scheme when it had been accepted with regard to its main features that it was reasonable. The Court of Appeal allowed that appeal, and they concluded that the judge had erred and had reversed the burden of proof impermissibly. In fact, it was for the applicants, the claimants, to prove the scheme was unreasonable. It wasn't for the defendant to prove its reasonableness. And in fact, it was a high threshold. They'd have to show that the basis on which the decision was made was one that no reasonable management company could have adopted in the circumstances of the case. So that was one in which the scheme was upheld as reasonable. And of course, what can be noted by way of difference between that and the previous case is this was a situation where the management company were not seeking to undermine rights under the lease, as in the Said case, in which the landlord had been attempting to profit from the sale of the further flats that were being developed, together with parking rights. But here, what was attempted to be addressed was introduction of a fair scheme whereby it served all of those lessees. And the final of these cases is the Montrose Court Holdings case, which involved a paying permit system and the issue as to whether that was lawful. It was alleged by one of the occupants that they had an easement of parking, and so a new permit system was unlawful and an unlawful interference with that easement. The Court of Appeal rejected that argument on an appeal, and they held that the purpose of the regulations was to allow those with the right to park to compete for the available spaces, and in those circumstances the scheme was valid. So that was a slightly different way of looking at the situation. But these parking scheme cases are quite useful, and these kind of issues commonly arise. So you can see the three different ways in which the courts have dealt with those kind of schemes. I'm going to move on now to just set out quickly a principle in relation to relief. The B&Q case involved a dispute about a right to pass and repass, and effectively whether there was an extent, the extent to which vehicles were permitted to wait in the yard. The primary arguments in the case concerned those issues, and an injunction was granted for B&Q, and that is fairly routine arguments on these rights under leases. But what's important about this case is what the test was for relief, and that's why this case is a particularly important one. Effectively, the test is one of convenience and not necessity or reasonable necessity. Providing that what the grantee was insisting on was not unreasonable, the question was, can the right of way be substantially and practically exercised as conveniently as before? And applying that test to the facts, the difficulties caused to B&Q and its suppliers justified the complaint. And there's quite an important review of the authorities in this decision. And it's one that's been applied quite recently, in fact, in the Vance and Colleton case that I mentioned earlier, in which the relief obtained by the Vances with regard to being able to assert their right to enter the drive in the way they chose was one based upon this authority, albeit not terribly important in circumstances where the Colletons were then able to park further up the drive. But this is the test, this is the core test. Now, the final topic that I'm going to deal with relate to a couple of public law issues. And the first of these cases is one that I only mention because in deference to the fact it is a Supreme Court case, because it's probably not something of hugely wider application, but is perhaps a lesson in a lesson that most lawyers know, which is lawyers are too wise to litigate on their own behalves and to get embroiled in litigation. In this case, poor Mr. Cusack was a solicitor who was subject to proceedings by the local authority to stop him accessing from the road his property. They were concerned about the danger of that access and took proceedings against him. He was concerned about the fact that they elected to proceed under legislation which didn't require compensation to be payable in circumstances where there was alternative legislation which they could have used, whereby he could have acquired compensation. And in those circumstances, he said it was a breach of his Article 1 Protocol 1 rights. Well, that argument was rejected by the Supreme Court, and his right of parking was obstructed. Of perhaps more relevance to cases that arise on a general basis are the following line of authorities which relate to planning obligations. The first of these is the AS Property Investments case, in which the developer refused to enter into a Section 106 planning agreement regarding preventing the grant of parking permits to residents of new flats. But that was swiftly circumvented by the local authority by excluding each of those new flats from the schedule of streets in the statutory instrument involved in a controlled parking zone. That solution was upheld by Mr. Justice Sullivan, as he then was. And the Section 106 obligations continue into the next couple of cases. The first of these is the Westminster City Council case and Secretary of State on slide number 54. This involved a planning application to allow the conversion of garage into residential accommodation. Permission was refused and was appealed together with an offer of an undertaking from the owner not to apply for a parking permit and agreeing to notify prospective purchasers that they weren't entitled to a parking permit. And that planning appeal was successful. However, that decision of the planning inspector was quashed on appeal because the undertaking was regarded as personal, and it was considered and held that that was not a valid planning obligation pursuant to Section 106 of the 1990 planning legislation, and in those circumstances it couldn't be enforced. Now that's an important decision which was followed in the final case that I'm going to address, which is Kerry, and this is a similar case involving parking pressure in the area, whereby the local authority in this case required the developer to enter into an obligation. But it was considered in this case similarly that Section 106 was not capable of biting these kind of circumstances involving residential parking permits. It's a decision of the Court of Appeal, and it was considered that the only land identified for the purpose of Section 106 was the building itself, and the use which the local authority sought to prevent was not use of any particular fact in the building, but use of the highway for parking, and it was considered that that was not a use of the property. Therefore it could not be a planning obligation. Now that line of cases are important, particularly in areas such as central London, which is where these cases tend to arise, where there's such pressures on parking, and local authorities want to try and retain as much public parking as possible. The 106 route seems to have been pretty much closed off at this stage. Now, they are the topics that we wanted to cover today in this session. As I say, we're very much open to receiving any questions that we've got that you have in writing. Our details are set out at the end of the slide, and please do feel free either to email us or to telephone either of us in order to ask any questions about these topics. It is a ripe area of the law, and it seems one that people are very willing to litigate. It's going to be quite interesting to see what the effect of the current pandemic is on cases involving parking, because I've seen so many over the last few years. It may be that people are commuting less into central London, so there's less appetite in central London for disputes about parking. But equally, it may well be that properties in London are used for different purposes, whereby perhaps parking becomes more important, and so there are different forms of disputes. Anyway, I'd like to thank you very much for joining me. We've enjoyed speaking to you, and I'm going to just hand back now to my colleague Gemma, who will also say goodbye. So thank you very much.
Thank you, Kerry, and thank you everyone for joining us. I have just had a look in the Q&A, and I can see that a couple of people have sent questions in. As Kerry says, due to time, and I can see that one of them is quite a long question from Anonymous. So if you are still listening, hopefully you're still with us, Anonymous, if you can drop us an email, then we can get back to you. And the same with the Sweeter, who I think I do know who that is at CMS. But if you can drop us an email, then we'll get back to you. But thank you very much for listening this afternoon, and we look forward to seeing you again soon. Take care.
Thank you. Bye-bye.